many reactions, and now let's get the reaction of Senior Advocate of Nigeria. We have in the studio with us Dr. Adekunle Ojo, SAN. Thank you very much for joining us.
Thank you so much. Happy to be with you this morning.
Happy to see you, and Happy New Year.
Thank you. Same to you.
All right. So, out of these 8 states that had, this crucial judgments delivered at the Apex Court on Friday, 2 stood out. The case of Kano and Plateau states. Now the Supreme Court has spoken. The dust hopefully has settled down. It's jubilation, at least from the camps of the governors whose elections were affirmed. But looking at the reasons behind affirming their elections, how did this judgment meet you?
Well, in all fairness with you, I'm one of those who believe that the Supreme Court is a policy decision-making court. Whatever is decided as the Supreme Court, we are bound by it, and it's bound to be followed by every other court. So, basically a scenario occurred, like the Kano one. It was an unusual one. This is the first time that we are getting to know that if the ballot boxes were not signed properly, the ballot papers were not signed properly, that is the result, that it won't count. That was the basis upon which 165,000 votes were removed from the governor's vote. And apparently it's a new one. And getting to the Supreme Court, yes, said, one, it was not disputed by INEC. Then you shouldn't make the party to pay for the fault of INEC. So, and this is a growth, this is a development in our jurisprudence. That's the way I say it. For me, really, it's not about who won and who did not win. It's really about advancing the cause of justice. We now know that, look, whether it is signed or not, for as long as it bears the INEC emblem or the logo, then it becomes acceptable. That's a new one. But assuming if the Supreme Court had gone the other way, then we'll be saying something else now.
On a lighter note at the moment, because I want you to relax and enjoy the show this morning. It seems that all the governors, the 8 of them, were aware about this particular judgment. They were present in court. You will agree with me?
Well, it's the right of it.
It's their right.
Yeah.
But one thing that is very crucial at this time that I want us to look at, quoting Justice John Okoro, that judges should be meticulous in doing their jobs to avoid the mess that happened in the lower court. Is this not a...
I think this was given in the Plateau case.
In the case of Kano, are you not worried about some of the judgment that emanated from the appeal court now being upturned at the Supreme Court?
No, I'm not disappointed about what happened in Kano. Like I said earlier, it's a fresh one. It's a novel position. It has not happened before. So apparently, it's been decided now. We can stand by that. But then coming to a Plateau, in all fairness, I think some people have been wronged. Unfortunately wronged, because we all know that when you have a pre-election matter, it can only be within the party circle. It is not for an outsider to dispute. APC has no basis challenging how the primaries of PDP was conducted. That's the truth. So it is the parties. If you really participate in a primary election, then how come you are alleging that it was wrongly conducted? That somebody was not qualified on basis of how the nominations were done. I think it's a party issue. But apparently, if it's a constitutional issue, then you go, maybe he didn't have the necessary requisite papers to contest. That's a different thing. Like the issue of Plateau now, pre-election matters. Just like in the case of Asiwaju, if you remember so well, somebody opposed that Shetima was not qualified on basis of double nomination and all whatnot. And it's none of your business. As PDP, as
Does that serve as a judicial precedent?
Yeah, it's a precedent.
Future occurrence.
Yes, it is. And even before we had this, there are several other cases. So it's unfortunate that the Plateau House of Representative members,
the House of Assembly members,
and senators are to pay. The same thing. That is the basis upon which Lalong is a senator now. So I think it's pretty unfortunate. And it's unfortunate in the wise that the justices, with due respect of the Court of Appeal, did not look at precedent. Otherwise, we should not have this. And you can imagine the Supreme Court Justice Okoro saying that we are sorry this happened.
It's unfortunate.
It's a mess. That's the bitter truth.
But
unfortunately, it can't be corrected.
But unfortunately, it cannot be corrected. Leonard Suk, but part of the reasons that formed the decision at the lower court, the Court of Appeal, was the existence of a court order that said that elections should have been made. Was it at the ward level and all of that?
No, it was an issue of recognizing one ESCO and not recognizing the other.
Yeah. But the Supreme Court spoke on that and said it had no business. It had no business.
If you remember, you see what they inked upon was the old case of Sanfara, the Yaris matter. Basically it was pursued by Marafa. Marafa was a member of APC. He went all the way through the High Court to the Court of Appeal to the Supreme Court. So at the end of the day, the Supreme Court said, yes, you are not qualified because the people, your primary was contested. I mean, the faction that can organize your primary, they were not eligible to do it. So that was the basis upon which the Sanfara, or the Matawale, that was how Matawale became governor, and all the members of PDP and all whatnot. So assuming this case was pursued by a member of PDP, it would have been a different thing entirely. Okay. But because APC has no business talking about how the primary of PDP was conducted, that was the basis of the decision of the Supreme Court now. And I think I agree with them. That's the truth.
But how do we clear the mess that has already... Of course, people have said this has gone. But,
for future occurrence.
For future occurrences, what recommendations would you be making?
Let me say, this has gone, quote and unquote. But basically, people will still look, can we do something about it?
Can we?
Yes. If you have a judgment, if you have a decision based on some level of misrepresentation, if the law was murdered in between, somebody somewhere can come around and say, look, I want a review. Yes, you can basically come out and say, I want a review of that decision. I'm not saying people should go back to court, but I'm just saying if I were to be in the shoes of the lawyer.
So are you advising those Plateau lawmakers and the election that brought in, the decision that brought in, like,
it's about,
it can be reviewed?
It's about
what you're saying.
It's about election. If I were to be in their shoes, I would seek for a review. But apparently because I'm not paid to do that, I'm not paid to do that, so I won't do that. So basically it is for them to elect on what to do and what not to do. But apparently with what has happened, it has opened another vista. It has opened another avenue for people to say, yes, what can I do? Let them try their best. It might not work.
And what would be the wisdom of that? Because, of course, election petition cycles have a beginning and have an end date. Yeah. Would that be a problem for anyone who wishes to review?
Yeah. Basically, if your decision was wrong, for whatever judgment, if your decision, even if what they will get at the end of this, yes, assuming it is within the 180 days, we will have reviewed or we will have done this, that is even comforting enough for you to know that you are not rightly edged out of your position.
But if you look at this, let me quote this particular quote coming from the former U.S. Attorney General. I'm talking about Robert Jackson, saying that we are not final because we are infallible. We are infallible because we are final. So some of these decisions made are coming from these judges or justices are also humans. Yeah. They can make error. Would you agree with me on that?
Definitely, they do. So, like any other human being.
So, what are the lessons that we need to get from this particular judgment?
The lessons that we need to get is, unfortunately, the lessons have always been there for us to learn from. There are times the euphoria of the moment or the thinking takes us away from looking at it. Like I said earlier, like the decision that has just been made by the Supreme Court, they are not entirely new. The only one that appears a bit new was the Kano one, because it was a fresh issue. So having said that...
Which was covered by the new amended, new Electoral Act
2022. So I think what we need to do is let us be a bit patient. Let us not throw... Because, you see, if you remember so well, like what happened in Rivers State, was exactly the same thing that happened in Sanfara. But the Plateau situation is a bit different there was a decision that this faction can hold an election. This cannot, or you should not go ahead based on judgment of Justice Omotosho of Rivers State. Apparently, they went ahead, and the court said everything that you did were void. So, having said that much, then going further, it was decided by some members of the party that they were going to dispute it. Unfortunately, this was not done in the case of Mutfwang, Caleb. So it was another party that did it. I think a lesson for us to learn is let us exercise enough patience, enough caution in whatever we are doing. And apparently too, perhaps we might have to, yes, we crave that based on the Electoral Act, that some of the cases should stop at the Court of Appeal. But then we are beginning to see now that perhaps if we had allowed it to go to the Supreme Court, might be different. That is the only lesson that I think we can learn from. Because it's not about the law. We all know what the law, the situation is. Yes.
Right. But still on this issue, apologies, Emmanuel, still on this issue of, calling for reforms, it was suggested that, and it is being suggested that, election petition tribunals, even if you want to push it to appeal stages and all that, that we should have, it comprise of justices from the High Court, the Court of Appeal, the Supreme Court, and as at the time when this reform was being called up on, this issue, or the Supreme Court had not yet spoken on the issue of Plateau State. But how do you see now? Because we saw the court giving knocks on the Court of Appeal, not just in Plateau State, but even in other cases where there were some, in the mind of the Supreme Court, aberrations.
Some of the lawyers as
well.
But imagine having made so much effort, so-called effort, and the justice said, this is nonsensical.
Nonsensical. In the word.
Let's just quickly add this so that you can answer the question together. Are you not worried or concerned that some of your colleagues in the legal profession don't give the right advice to their clients? Yeah, we don't need to pursue this case to the appeal court. Let's just end it here. You have lost this election. Go and relax.
Right. So I want you to take the questions, from the issue of where the Supreme Court overrules the Court of Appeal. In this case, now a case as controversial as Plateau State, and of course on the other issue of lawyers and how far can lawyers go in defending their clients?
We're coming to. Let me start from the last question, and my answer to that really is that for whatever you do, there must be a reward for doing well, and there must be consequences for doing very badly.
Absolutely.
The position of our rules of professional misconduct as we speak now is not good enough. Some of the things that we try here in Nigeria, nobody would dare do that in UK. You took a judgment on the basis of a position that you canvassed, and you go back to that court and you are canvassing a different position at a later date. Just like it happened in the Ondo State, in the case of Atiku Abubakar. The position canvassed by one of the lawyers in a different case that he won. He now turned back to the same court to canvass a different position. Nobody dare do that in UK. Apparently, it's going to be removed from the role. It does not matter how far you have gone in the profession. And I think we need to get back to that. You canvass A today and the court says you are right. Tomorrow you turn around to say that A that I canvassed is no longer.
Same case.
You need to explain how it has changed. So apparently we really need to, because you imagine like this issue of dual citizenship
in Lagos.
It is firm. It is clear that you, for as long as you have now renounced your citizenship of your of birth, you're being a Nigerian, you are born here in Nigeria. Nobody can take it away from you except you elect not to be again. So you can take whatever you want to take elsewhere for as long as you keep your Nigerian citizenship. So, but you imagine somebody still canvassing that.
And Section 29 is clear.
Very clear about that. You get to the Supreme Court again, what has been decided in Shetima, you are still canvassing it. And I think there are a lot of things that we really need to look at. Then coming to the later question, it is neither here nor there. The reforms, as it is, the justices, they are human beings. You can get 11 people to sit on the matter, and the 11 may still be wrong. And you can get 5 people to sit on the matter, and the 5 are right. I think basically it's about giving some level of credit to some of these justices. Before we got to this level, there were competing tensions. almost everywhere. In Kano, this was going to happen, this will happen, and whatever. And look, we need to develop, we need to evolve. We need to see democracy as an evolving thing in this part of the world. When I'm successful in a case, then that case, the judges are good. But when I am not, the judges have taken. And I want to appreciate one thing in our Supreme Court. They decided their matters without having to wink at the sight of any demagogue. Because if you consider how much pressure coming from all the sides, but they decided in the Naira case. You remember the Naira
cash crunch.
You understand? Right. They decided and so, oh, this is very wonderful. But when they decided, remember in the Obi case in those days, when they decided you are this, people say good. But when they decided against it, people say, but no, we should just have that culture and we should begin to respect our institutions.
A particular headline story this morning said the judiciary, with the fallout of the judgments of the Supreme Court, is trying to restore its integrity.
It's not about this.
Is that how you see it?
No, that's not the issue. The integrity has never dwindled at any point. It has not been diminished. It's a matter of art. It's about how you see it. For somebody like me, the Supreme Court has been an epitome of integrity. The men that occupy that seat, they have so much to do. Like he said, you can make errors. You can make mistakes. Nobody is infallible, that's the bitter truth. But having said that much, there is no basis for anybody to impeach the integrity of the Supreme Court. What we are craving for is that let there be a judicial attitude. Judicial attitude in that whatever is said by the Supreme Court is followed by everybody. Let us know. Let us have some level of precision. Let Kemi be able to say yes, because this matter is in court based on this similar. There are no two facts are always similar. But then, to a large extent, let us be able to say this is how this court will go. If there must be a deviation, this is the attitude that we are asking for. If the Supreme Court can do it, then we are there. But then about integrity, I don't really. There is nothing to restore.
But quickly, when you look at what the Supreme Court has done so far in this cycle of election, that attitude of, predicting somewhat, safe predictions of how the Supreme Court will swing, presidential election tribunals, and even up until now, have you been surprised or satisfied?
Yes, in all fairness, with you, with myself, with the Supreme Court, they have done pretty well. Like I said, the only issue that I consider a bit novel is the issue of Kano. Every other one appears to be, look, without facts, you are coming around. Like the case of, is it Jando now? I can't remember.
Lagos.
One of the cases, they said you brought your matter outside the requisite time. It has lapsed. That's enough.
I think the judge said it's an academic exercise.
Yes.
Absolutely.
Yes. So at the tribunal, that's as far back as at the tribunal
stage.
You went ahead to appeal to the Court of Appeal. You went ahead to go to tribunal. Why are you wasting your time?
So, is it that some judges or some lawyers don't know this term which says rep ipsa loquitur, that fact
speaks for itself? So I think basically we need to firm up our rules of conduct. We really need to look at it. Is this professional alone? Have you done the right thing? In fact, we should get to a level that clients will start suing lawyers.
Okay, quickly, we've run out of time, but how do you think Governor Caleb Mutfwang is going to work now with House of Assembly dominated by the APC?
But you know, this is Nigeria again. For people to cross carpet, it's a very easy thing. And for people to agree with you, to compromise, it's much, much easier. And you don't forget that the governor of a state has so much power, so he can make things work. I think basically they will align, they will agree. It happened in Osun. Everyone did not fall. Even while Adeleke came in, the majority of the House of Assembly members, they were of the APC side, and they still had a way of working. And above all, it's about you do your job properly, let me do mine properly. So I think he would have problem. He's a lawyer by training. You should be able to get them to work with him.
Dr. Adekunle Ojo, we thank you very much. Alenet Silk for speaking with us on TVC Breakfast. We really appreciate your legal insights this morning. All right, still on TVC.